Hi, my name is Mike Meehan, and I'm an attorney employed by the Cleveland Clinic. In a very general sense, I'm going to discuss what we lawyers call estate planning. My comments are intended to be educational for you and should not be construed as legal advice. Estate planning is that area of the law that deals with wills and trusts and powers of attorney and prenuptial agreements. And I will also talk a little bit about advanced directives such as living wills and durable powers of attorney for health care. This area of law is regulated on a state-by-state basis. Since the Cleveland Clinic main campus is in Ohio, the law that I will describe will be Ohio law, but whether or not you live in Ohio or plan to work in a different state, you should consult an attorney licensed in the state that you will be in who is knowledgeable in estate planning. Also remember that laws can change, so it's important that you engage an attorney. An attorney should be conversant in the current state of the law for this purpose. So let's talk first about wills. A will. This document is commonly referred to as a last will and testament, not to be confused with a living will, which is an advance directive relating to patient care. A will is a formal document that lets you provide for the distribution of your estate when you die. What's an estate? An estate consists of real property like land, personal property like stocks, cars, and bank accounts, and intangible property like claims or rights that you may have. At your death, these items together are what is referred to as an estate. So your will would describe who you would want each or all of these assets to be transferred to when you die. If you die with a will, the court will appoint a person to carry out your will. That person is called an executor. If you die without a will, you are said to have died intestate, and the person appointed by the court to administer the distribution of your estate is called an administrator. In that case, if you die without a will, your assets generally would be distributed in accordance with Ohio law or the law of the applicable state. These state statutes can be complex, and depending on the nature of your family, your estate could be distributed entirely to your spouse, or it could be divided among your spouse and surviving children. Having a will avoids a distribution of assets in accordance with state law. Having a will enables you to have your assets distributed as you would want them distributed. Individuals often use wills to make a bequest of specific real or personal property, make special provisions for certain property or persons, recommend an executor, provide for charities or individuals outside your immediate family, recommend a guardian for your minor children, to disinherit someone, or to leave an entire estate to a spouse who would receive only a portion under the state statute. Anyone who is mentally competent and not under duress or other type of restraint can make a will. The person making a will is called the testator. Wills must be in writing, although they can be handwritten or typed. I will discuss in a moment what some refer to as verbal wills. In Ohio, the will must be dated and signed on the last page in front of two competent witnesses who must also sign the will. It is a good idea to keep your will in a safe place where it can easily be found after your death. Many people like to leave a copy with the attorney who wrote it for them as well. And you should tell your executor where a copy can be found or give a copy to the executor. You can distribute almost any land or personal property that you own at the time of your death through a will. There are some exceptions, like property interests that end at your death. These are called life estates. Bank accounts or land held jointly with a right of survivorship. Life insurance death benefits that are made payable to specific beneficiaries. Retirement plan assets and IRAs that are payable to specific beneficiaries, and other interests established that specifically transfer upon death. Executors are usually Ohio residents, but they can live out of state if they are related by blood or marriage, or if the other state permits it. Under Ohio law, if your spouse is omitted from your will or disagrees with the will, he or she can instead choose to take that part of the estate that he or she would have received if you had died without a will. This must be done within 5 months from the court's appointment of the administrator or executor. A child, on the other hand, can be disinherited, that is, completely removed from receiving any assets, but that should be stated in the will. Your will can be changed at any time prior to your death. If you revoke a will, it means that the will has been canceled and is no longer valid. Wills can be amended with documents called codicils. The codicil must have all the formalities of the original will. For example, it must be in writing, it must be dated, and it must be signed by you and 2 witnesses. Your will can legally affect the distribution of your property only if it is filed in the applicable court, which in Ohio is the county probate court. If you lose your will, or if you inadvertently destroy your will, you should make a new one. If you have a valid written will, a verbal will is not valid. Verbal wills are not valid in regard to land. How does a verbal will work in Ohio? If you are dying and verbally say what you want to 2 competent, disinterested witnesses, your wishes will be honored if they put the will in writing within 10 days. Wills from other states are valid in Ohio if they are valid in the state in which the wills were made. Sometimes people legally avoid the probate process for some or all of their assets by either holding property jointly with the right of survivorship, establishing an inter vivos or living trust during their lifetimes, or establishing bank accounts or deeds that transfer interest at death. These alternatives should be discussed with an attorney. An inter vivos trust can be created with the assistance of an attorney. For example, property that would have gone into a probate estate can be transferred into a trust either during your lifetime or at your death, and the trust would be administered and its assets managed by a trustee that you name. A trust document is a different document than a will, but they can be constructed to work together. I also want to mention powers of attorney. A power of attorney is a document that authorizes a second person, such as a family member, known as an agent, to act on behalf of the person creating the power of attorney, who is called the principal. The word attorney in this context refers to a person empowered to act on behalf of a principal and does not necessarily refer to an attorney at law. General powers of attorney enable you to name someone as your agent to make business, legal, and financial decisions for you if you are unable to do so for yourself. Powers of attorney can be created by individuals only while they are mentally competent. When a power of attorney is intended to survive the principal's incompetence, the power of attorney is written in a way that makes it durable. This general power of attorney is different than a durable power of attorney for healthcare, which is a healthcare proxy document. Sometimes, after persons lose their mental competence, general powers of attorney are used as an alternative to guardianship because court-appointed guardians have probate court oversight, which can be administratively cumbersome. Sometimes lawyers may create a power of attorney for a client and not release the document to the agent until the principal's physician indicates that the principal is not capable of handling his or her business affairs. Broad-purposed powers of attorney are powerful legal instruments and should be created with the advice of counsel. Your attorney can advise the stage of your life and the circumstances for which a broad-purposed power of attorney makes sense for you, if that be the case. As physicians, you understand the value of having advance directives, such as living wills and durable powers of attorney for health care. You should consider executing one or more advance directives for yourself. Advance directive forms have been standardized in many states jointly by bar and medical associations and are often available online. But receiving legal advice regarding advance directives can be very useful, and an attorney can help you with that as well. Finally, let me say a word about prenuptial agreements. A prenuptial agreement allows two individuals who are entering marriage to put restrictions on the amount of property each will receive from each other in the event of divorce or death. The laws vary by state. In order for a prenuptial agreement to be valid in Ohio, each party, the husband-to-be and the wife-to-be, must be represented by separate legal counsel and must make full disclosure to the other person of his or her income, total assets, and expected inheritance. In a divorce, a judge has the ultimate authority over a couple's division of assets regardless of the terms of a prenuptial agreement. These prenuptial agreements can have a chilling effect upon a marital relationship, and they are relatively uncommon in first marriages. Prenuptial agreements are more likely to be seen in later marriages of both parties and are often used as a vehicle to ensure that children from earlier marriages are taken care of. Finally, let's spend several moments about hiring an attorney. As you embark upon your professional career, it is advisable that you find an attorney who is familiar with general business principles such as business contracts and estate planning. Like physicians, attorneys specialize, and you should have someone that you can call who is available to answer your personal and business questions. Attorneys competent in these topics can be identified by contacting the local bar association and asking for the names of the members of the estate planning committee for that bar association, or the committee that oversees its general business group. I recommend not retaining an attorney that already represents either the hospital or the physician group with which you would be practicing. This avoids conflicts of interest down the road. It may be advisable, however, to contact the hospital's legal counsel and ask for recommendations of other lawyers who are respected in the area. Well, that concludes this presentation. I hope these few minutes have helped in your understanding of the world of estate planning. I wish you the very best in your future professional endeavors.